questions, answers to legal questions about special education. And our presenters today are Kirstein and Beth Rydberg. And the session is being sponsored and brought to you by Disability Rights Iowa. So with that, we'll get started.
Good afternoon. I'm Beth Rydberg. I'm a senior advocate at Disability Rights Iowa. I'm also the parent of adult children with disabilities. I will also just briefly introduce Jane Hudson, who is in the back of the room. She is our executive director. And
I'm Nathan Kirstein. I'm an attorney at Disability Rights Iowa.
I'm going to tell you just a little bit about Disability Rights Iowa. If you're not familiar with us, we are Iowa's designated protection and advocacy. Every state and territory in the country has a protection and advocacy. We are written into a variety of federal laws to provide advocacy assistance to persons with disabilities with disability-related issues. So in general, that means if you are an Iowan with a disability-related issue, you can call Disability Rights Iowa, and we may be able to offer you some kind of assistance. It might be that we refer you to the appropriate place. We might be able to provide a little technical assistance. We might be able to provide some advocacy assistance, or we are a legally based organization, and so we have attorneys experienced in civil rights law regarding people with disabilities. We serve across a broad spectrum. Nathan and I are both part of our children's team, so we're working with kids in juvenile justice facilities, kids in schools, kids in the community. We also have adult teams that work in the community and within institutions such as the state resource centers, ICFIDs, prisons, every place where a person with disability might be served. We have a very large focus on abuse and neglect. So we are really looking for those kinds of things that might be pretty egregious, that we can go in and help make changes not only for individuals but also changes into systems.
So this presentation is just going to be kind of the basics of special education law, broken down into some frequently asked questions that we receive. We ask that if you do have questions, if you wait until the end, because we might actually end up answering that question throughout the presentation. But jot it down, wait to the end, and then we do want to have time for questions at the end as well. And that might help us get more time at the end to be able to answer what it is that you all brought, to this place today. So, first of all, let me get this thing.
We only have one microphone system, and we will be out. When you have a question, we will bring you the microphone so we make sure that everyone can hear. But we're doing a little dance here back and forth.
Okay. So, first and most important part is who is part of the IEP team, because the IEP team makes all types of decisions, right, about the child's educational program. And I think it's very important to note that child and parent are equal member of the IEP team, along with a special education teacher, a gen ed teacher, and someone that can make decisions about resources, which is oftentimes principal or superintendent. Now there's a couple other folks, but before I go to them, I want you all to think gen ed teacher needs to actually be someone that can speak towards the gen ed curriculum in the child's goals on the IEP. So if they have a math goal, reading goal, things like that, you should have a gen ed teacher that can talk about the gen ed curriculum as it relates to those goals, right? It shouldn't just be some, the gym teacher that teaches gym and that's about it, and they stop in and they really have nothing to relate about the gen ed curriculum for your child's goals. So something to watch for in that. Also, so someone that can interpret evaluation results. So that someone could be school psychologist, occupational therapist, speech pathologist, anyone that might be talking about an evaluation or the results of data that's been taken on the child. Also, any other individuals that have knowledge or experts regarding the child. That includes folks in your child's care team, so that might be private nurses, private psychologists, and of that sort. And you can request them be at the meeting, and they should indeed be there if they have something applicable to share about that child at the meeting. So a lot of times we get this question of, so-and-so is not coming to the meeting, why? And it oftentimes happens right before the meeting. Well, the law requires that, so all those folks that I kind of talked about just before that are part of the meeting, that should be part of the IEP team, if the parent and district agree in writing beforehand, and that person has nothing to add to the meeting, then that's fine. Or if that person has something to add to the meeting, like it'd be someone that's going to interpret some evaluations or something like that, and they just can't be there, family emergency, whatever, right? Life happens. So then they need to be able to provide something written about the information they would have provided if they're at the meeting, along with the parent and school agreeing that that person can be excused. What we see a lot of times is you show up at the IEP team meeting and you look around the room and you're like, and someone asks, what are you looking for? And you say, the gen ed teacher, because they're not here. And they say, oh yeah, that's right, here. Here's an excusal form. Why don't you sign this? Well, okay, that might meet the legal requirement, possibly, but you got to ask yourself the question, does that person have something to relate to what it is that we're talking about here? And if they do, why wasn't I notified beforehand? You know, and why wasn't I given something in writing that gives me what that teacher would have been able to provide, or that person would have been able to provide at the meeting? Okay, parents. There is a legal definition of parents. I'll let you all read that for yourselves in the handouts. But something important to note is two things here. Foster parents, if there's any foster parents in the room, you have to have a specific court order that provides you with educational decision-making rights. So if that wasn't signed by the court, and you just have actual a guardianship of the child that's kind of custody guardianship, and it doesn't sign over specifically educational rights, those rights remain with the biological parent and don't go along with the foster parenting unless it's in the court order specifically. The other thing to note is if there is a child that's a ward of a state, I don't know if we have any social workers here. This is something to pay attention to. If both of the parents' rights have been terminated by the state for the child, and the child doesn't have any biological parents with rights anymore, then they're considered a ward of the state. If they are a ward of the state, a surrogate parent must be appointed. The AEA can do that, or the district can do that, but it should not be like the DHS worker or any other state employee, because there's an inherent conflict of interest in that. Okay, IEP meetings. Yes. So exactly, because you all have probably been in this situation or have heard of one where it's difficult to find the time to meet, or the school has sprung a meeting on you and you say, what? I didn't know that. Or you say, this is my schedule, I'd like it to fit my schedule, and they say, we don't have to do that. Well, yes, they do. Both the school district and yourself need to cooperate on finding a mutually agreed upon time and place. And then the school has to send out a notice, paper, 10 days prior to that meeting. Now, are there instances in real life that, you need to have a meeting quickly because some things are going down and you really need to intervene and the team needs to meet, and everybody's agreed that that's okay, that you're going to meet in like 3 days, and they don't get you a notice within that time? I think that's fine, right? This legal notice, the whole point behind it is that you don't get just things sprung upon you as a parent that you haven't agreed to and you don't have time to prepare to get to. Does that make sense? Okay. This comes up in a few different areas, the independent educational evaluation. So one would be the initial request. My child does not have special education services. I think my child needs them. The school evaluates and says, no, they're not eligible. Then you have a right to an independent educational evaluation. Other ways are maybe they have an evaluation in a different, your child's already on an IEP, eligible individual, and there's other areas of need that have not been evaluated or explored yet, right? And you want an evaluation, and the school does one, and you don't believe in their what they have to say is true, or you think they've missed something, right? Because your experts, or you as a parent in your own expertise, believe they've missed something. Well, then you have a right to an independent educational evaluation, which means you can request that from the school. The school has to pay for it, and it has to be by a qualified examiner. Now, the AEA should have, doesn't always have, but should have, lists of what would be qualified examiners. However, it doesn't necessarily mean you have to choose someone off that list, but it has to be someone that can't, they got to be qualified for what they're doing. That's the bottom line. And use your common sense with that. And the results must be considered by the school. So the results of that evaluation must be considered. You don't have to tell the school district or the AEA why it is that you think their evaluation's wrong before you actually get one of these. That's not required by law at all. You just have to request it, and you get one of these for each time the school district does an evaluation or should have done one, and and you don't agree with it. So we don't do that here. We have heard that a few times from school districts when something's asked of them that would be good for the child to have as part of their supports and services, or if they have a mental health condition, they say, well, we don't do mental health here. That's not what we do. That's just not the right answer. The right answer might look like, we don't know how to do that here, or we don't have the appropriate supports and services here, but we're going to figure it out. And if need be, and they have to go to some other school to receive these, then we're going to figure that out together, and we're going to look at this, right? And decide how this is going to happen. But just to say, we don't do that. That's an incorrect answer. And here I have some cited law, right? So what is our basic principle about the IDEA is that free and appropriate public education is available to all children with disabilities residing in the state between 3 and 21 years of age, right? So, what does FAPE include? Because there's a lot of discussion about that, right? What is a free and appropriate public education? Well, in the law, this language is in there, and it includes special education and related services that meet the state standards and are provided in conformity with all these legal requirements of the IEP that I'm talking about today, right? Which, continued on, is what is special education? It's defined in part as specially designed instruction that meets the unique needs of a child with a disability. So all of that is to say that we don't do that here is an inappropriate response because it's not an individualized response. It doesn't talk about state standards, and it doesn't talk about what the specially designed instruction would be that would be needed in order for that child to access the gen ed curriculum.
So, one of those things that I'm sure you've never heard before, it is really fun to sit and watch your faces as we hit on some of these topics, because it's obviously we're not the only ones that have heard some of these things. We can't afford to do that. It's a free and appropriate public education. That means it's provided at public expense. It has to meet the state standards, and those state standards and benchmarks are on the Department of Education's websites if you want to go in and look, and your district may also have district standards. It has to be appropriate preschool, elementary school, or secondary school services, and it has to conform with the IEP. These IEPs are supposed to have they are supposed to have an educational benefit in the IEP. Now, courts have upheld that programs, we want to be really, really careful when we're talking about services and programs for our students with disabilities. Some educational benefit. It's some educational benefit. It's not the best. I've heard parents come up with fantastic programs that would really be awesome for their kids, but it's way above that standard of providing some educational benefit. So I would caution you when you're advocating for your child or your student with a disability to remember using those adequate educational benefit, not the this would be the very best thing for in the whole world, because that right away is going to be an argument for maybe, well, this we don't need to do all of those kinds of services. That's the standard. So one of the things that sometimes we say, well, maybe my child would be better off educated somewhere else. It isn't very often I get to do that. Hey. So one of the things we may say, well, you know, my child would really be better off being educated somewhere else. So there is this private placement option that's within the IDEA. So if the IEP team determines that private placement is needed for the student for FAPE, the educational agency has to pay. So if they say your student needs to go to XYZ in order to receive education, they have to pay for that. That's their responsibility. That was an IEP team decision. You as a parent, though, may also decide your student would be better educated in some other kind of private setting. And now I'm not talking about open enrollment or those kinds of things. I'm talking about maybe another specialized education setting where you feel your child would receive a better, adequate education. So if a parent decides that there's an appropriate private placement that's necessary for the child to receive a free and appropriate education, you have to do a variety of things. You first of all have to reject the plan that should have been written on a prior written notice by your local school district. Then you have to notify the school 10 days before you begin the child. You can't just call them up and say, hey, by the way, tomorrow they're starting. You have to notify in writing. This is very specific in the law, that you intend to place your child in an alternative placement other than what the school is, and you want the school to pay for that. Then you will have to go through due process if they reject your proposal to do that. Transfer of rights. They are finally 18. And there's a process within the IEP where the rights transfer from the parent to the student at that age of majority. Iowa, that's 18, just like it is for everything else. Schools have to start providing notice to students a year before that this transfer of rights is going to happen. If you look on your IEP, there's going to be something on your IEP that says when was transfer of rights information given, so that people can start preparing for that. You know, I think what we all go through, and this is with your typically developing child, it's like, I'm their parent. They live with me. Of course I'm going to make the decisions. No. That isn't how it works. With any 18-year-old, students with disabilities have those same rights. There's no requirement that you now be involved in that. Do they Does an IEP team still want your input? Absolutely. That's important. If your student is not able to make those decisions, there are alternative things that can be done. Many students in the past, people would just encourage parents to get a guardianship. Just get a guardianship, and now you can make all those decisions. We know that students don't need help all the time in everything. And there are lots and lots of different ways that you can have a limited guardianship or use alternatives to guardianship and conservatorship. And so we would really encourage you to explore what some of those things can be so that you can best support the independence of the student. We have not used it a lot, but there are forms on the Department of Education website for powers of attorney for educational decision making. So there are starting to be some things out there that might be an alternative to a guardianship or conservatorship. Yeah. I did think we warned you that this is it feels like kind of a random presentation, but this is really the kinds of questions we get over and over and over that are really kind of hard to find answers for. So I hope you're also writing down questions that you might have, because I see a lot of heads going, oh, yeah. So I'm interested to hear some of those things that our presentation now is sparking for you also. Bullying. Something that we hear about all the time. Yes, and we'll be glad to talk with you at the end, either to the whole group, depending on how much time there is, or come talk to us. And we do presentations on guardians. Absolutely, we've got a book out here that is alternatives to guardianships and conservatorships. Yeah, and that's an excellent question. And so at the end, if we've got a little bit of time to talk about it, we will. Otherwise, we'll direct you to some resources. So write that down on the list. Great. Bullying, something that we get over and over and over. Iowa does have a bullying law. The classes that are protected are fairly comprehensive. Students with disabilities are covered under this. Harassment and bullying is a lot of things: electronic, written, verbal, or physical acts. Those things that place the student in a reasonable fear of harm to the student's person or property. They have a substantially detrimental effect on the student's physical or mental health. They have the effect of substantially interfering with the student's academic performance. And they have the effect of substantially interfering with the student's ability to participate in or benefit from the services, activities, or privileges provided by the school. Did you hear an overarching word through all that? Substantially. That doesn't mean somebody just, nudged your kid out of line. We're looking at things that are substantial, that are happening to students, and there's no doubt in my mind that there are substantial bullying incidences that are happening to students with disabilities all the time. Schools have an obligation to investigate. Every school district has to have a policy for bullying and harassment, and you should be able to easily access that policy through the student handbook or on the school website. We have a button on our website that will take you to the Department of Ed's sample forms. It used to be that you had to fill out a form. You no longer have to fill out a form. You can just notify the appropriate people, such as a principal or at the school where your child attends. But we will always, always, always say the same thing. Anytime you're making any kind of a complaint or concern at school, put it in writing. That can be an email, that can be a letter that you've just written and taken. We would prefer, although we know people do it all the time, we would prefer it not be a text message. They're really, really hard to pull up as further evidence if needed be of notice or something like that. So use an email, hand deliver a letter, make a notation who you've done that to, but you can now notify just by talking with someone, but we would really encourage you to follow through with something in writing. Thank you for talking to me on such and such a date when I express concerns about my child and their name being bullied at school. Then the school must follow a procedure of investigation and action. Now we're going to talk very, very briefly about a couple different things that are going to be affecting our students with disabilities. ESSA, the Every Student Succeeds Act, will be taking the place of No Child Left Behind. We've had No Child Left Behind in action for a long time. You may have heard a lot of frustration from people about teaching to the test and all these requirements for testing, and that they really felt like it really, really missed the mark. Congress agreed. So now they have the Every Student Succeeds Act of 2015. It's going to replace No Child Left Behind. There will be federal determinations for what to do for schools that are low performing. It does not rely anymore on these annual statewide assessments. There's still going to be a lot of data collection that's being done, but there's going to be a much broader way that they're going to be able to do that. And it requires measurements of student growth in the curriculum. And for me, that's one of the big, really important things I think we've been talking about in special education for quite a while, about the achievement gap that our students in special education have between their typically developing peers. And how are we going to close this achievement gap so that we start to see students making 1 year's progress in 1 year's time? Every Student Succeeds Act is going to be part of how that's going to happen. This is one of those initiatives that's for all students, not just students in special education, that I think could be beneficial. Stay tuned, they're still writing the rules. So we'll see what comes out of that. The next one is the work incentives. Yes, but I've been saying it wrong. Work Innovations Opportunities Act. It's not incentives. So I have got to change my thinking here. The Work Innovations Opportunities Act. There actually is a presentation going on right now that's a little more in depth about the Work Innovations Opportunities Act. Part of this act's purpose is to increase services to youth with disabilities. And the emphasis is really going to be on getting more real-world experiences for kids. It's going to require the state vocational rehabilitation agencies to make pre-employment transition plans available to students with disabilities, and especially those students with disabilities that are going to be very, very high needs kinds of students. And there's going to be a prioritization of how VR agencies are going to be serving those students. And it's going to be dedicating funds to provide youth with the most significant disabilities supports to obtain competitive integrated employment. So what does that mean? Again, they're still kind of writing the rules and how they're going to be developing. But I think one of the biggest impact is that schools can no longer contract with those competitive integrated, with those sites that provide sheltered work, what we commonly know as sheltered work, where students go into these work opportunities where they're supposed to be learning pre-vocational kinds of skills, and they never leave there. They never learn any skills beyond there. Instead, what WIOA is saying is, first, these students need to be out into competitive employment. They need to have all these kinds of opportunities. They need to have these plans. We need to be trying to get them to that goal of a competitive wage. We know that if you live on a Social Security benefit, you're going to live in poverty for the rest of your life. It's not going to give you the opportunities that you would like to have. So now, instead of first allowing a student to go into these sub-minimum wage kinds of positions, they want students to be making attempts in community employment. So it's a real reversal of the thinking that we've had. And it'll be interesting to see how this is going to start to play out. Transition plans are going to start to become really, really important when we're talking about skill building for students as they're going through school.
All right, before I get into the next part of these slides, I'll just add a little bit as an aside. With bullying, there are legal claims that have been made, and courts have made some decisions based on bullying as a denial of the child's free and appropriate public education under the Individuals with Disabilities Education Act. They're tough ones to win, but they have to do with when a student has been bullied pervasively, so it's happened over an amount of time. The school had to have knowledge, and the school then did not do anything about that knowledge. Now, what that means, how I see that playing out in the practical world is, let's say you let the school, there's pervasive bullying going on, you let the school know what's happening, and they don't follow their bullying procedure that they have to do by Iowa law, and they don't follow that procedure out, then I think you got something there. And I think they violated the IDEA and denied your child a FAPE in some way, right? But if you've notified them, let's say, and they followed their procedure, and they didn't find what you think should be found going on, you have a much harder case there, and I think it's a downhill slope from there for parents to win a case like that. And when I'm talking about winning a case like that, I'm not saying let's all go sue school districts right now, but I'm trying to give you some thoughts about what the legal implications are with bullying and how it relates to a student's rights who has an IEP. And I think we're going to see that continue to change in our court systems as more and more of these cases are tried. Right now it's kind of all over the boards. And then there was one other thing. Well, I'll probably get to it, or you might ask me a question that'll remind me of it. So this next question is about, are there protections for students who have not been evaluated yet? And why we're going to talk about this is because sometimes we see students that are exhibiting behaviors that are getting them into trouble, and they do not have an IEP yet, but should have one. And so that's what this has to do with. Before I get into it, I'd just like to say we're not talking about this in today's presentation, but we can in the Q&A period, and that is, what are the protections for a child on an IEP who has behavioral issues and is getting suspended a lot? Because the bottom line is, when you read through the law, at the end of the day, the most important thing you can take home when it comes to behavior and protections under the IDEA is that your child can't get strictly just kicked out of school without any services provided to them at all if they're on an IEP. They have to have some type of services that allow them to progress in their IEP goals and access the gen ed curriculum. Now that might not be in the actual school building that they attend. It might be in an alternative placement. And there's a lot of nuances to this, and I can go through it later if people want to know about it. And it's somewhat complicated. But that's the take-home message. That's what you want to take home. Some type of services have to be provided to your child if they're going to be suspended from school more than 10 days in a school year. Okay? And no expulsions, meaning kicked out completely of the district. So are those protections available to someone that's not been evaluated yet? Or in And the question, this all turns on the question of, did the school have knowledge that this child was a child with a disability before the event that occurred that got them into trouble and maybe triggered more than 10 days out of school, right? Do you want to flip that forward? So what does knowledge mean? The IDEA defines knowledge as a parent expressing in writing to the teacher or to administrative staff or supervisors, right? That the child's in need of special education services, or parent has requested an evaluation, or a teacher has expressed to school district personnel, particularly special ed, the director of special ed, or some type of supervisory personnel, principal, superintendent of school district, I doubt it, but something like that, right? Then there's knowledge. I would say that practically speaking, sometimes this happens in the midst of an evaluation, and there it's obvious there's knowledge. Or, well, continue on that next slide. So there isn't protections if the parent has said, no, I don't want you to evaluate my child. If the school says, we suspect there might be a child that needs services under the IDEA, if the parent says, no, I don't consent to that evaluation, you can't turn around and then say, well, but I want the protections of the law. So that makes sense, right? And then, or they've been evaluated and the parent said, well, I don't want the services. Once again, you can't say, I don't want the services, but I want the protections. Or that the child was evaluated and determined not to be a child with a disability. But remember what we talked about before, previous slide that I talked about, that has to do with the independent educational evaluation. That's where that could kick in, on that third bullet point. If that occurs, you could have an independent educational evaluation at that point. So there's obviously this different parts of the law connects with each other. It's not necessarily, life doesn't happen on the slide, right? Go ahead. So, if there's no knowledge, then they do not have the protections of that they would receive under the IDEA, and but the parent may request an expedited evaluation. So this actually can occur if the school is just finding out that this individual might be a child with a disability in need of services, okay? And so you might say, hey, I want that expedited evaluation because right now my child is expelled for the rest of the school year and it's March, right? And so you want that expedited to try to get them engaged in some type of services, hopefully before the end of the school year. Depending on when it happens in March, that might be a bad example because the school has 60 days to evaluate normally, right? That's what they have by law. So an expedited is less than 60 days. Courts are kind of all over the place on that. Our actual circuit court hasn't made a decision about what expedited means, but I think you can make a good argument that at least half the time, so 30 days. I would try it. Go on to the next slide. So if the child is found eligible under that expedited evaluation, then they begin to have the protections under the IDEA. One other, yeah, I think I'll stop at that.
One other way that you can find out more about this child find process is by going on our website, your APA's website, or the Act Resource Center's website, and just type in child find. That's what this whole process is called. Specifically talking about the disciplinary process that might be happening while your child is being evaluated. If you want to learn more about child find itself, you can go on those websites and look at a series of 4 short videos to find out more information.
Okay, and here's when it comes down to the battle. We got the boxing ring here. Okay, so what are our dispute resolutions avenues? You know, when you're in an IEP team meeting, the IEP, part of the IEP team says, we think this way. When I say that, probably, right, it's going to be the school district and employees that say, we think this way. You as the parent say, no, I don't agree with that, and you're at a disagreement. What kind of rights do you have at that point, right? So first, if there is a disagreement about support services, educational placement, things like that, right? That you walk away from the IEP team meeting, you need to have at least either there at that date or very shortly afterwards, you need to have what's called a prior written notice. Don't worry about that name because I don't think it really makes sense because it says prior when it's actually a written notice after the meeting. So just think of it as you need a piece of paper that says what decision was made by the school district, what the options were that were weighed out, and where you stand as the parent, right? And at that point in time, that is kind of the trigger, the point at which you can do these things right here, and that is number one, you can file for mediation directly. Say, I want a state mediator to get involved with this decision that was made because I don't think it's correct. I don't think it's within the. You basically say it's a violation of the IDEA, right? And so the way in which you do that is you file a complaint, and there are forms on the Department of Ed website, or you get an attorney involved, or maybe you call Disability Rights Iowa, and that's how you file that. You send this form in that answers these kind of different questions on it, and it goes to the Department of Ed, and then they assign a state mediator, and then you go through the mediation process where you and others show up in front of state mediators and decide how you're going to negotiate this line in the sand that's been drawn by both parties. So, due process. That is a direct filing with the Department of Education that says we believe that our child's rights have been violated under the IDEA, and we want to have a hearing in front of an administrative law judge for them to decide what is to happen going forward, right? So this is a legal process, and this is where we would say you really should have an attorney. The school district is going to lawyer up when this happens. So you're going to want to have someone fighting for your side of things. Now, attorney's fees can be collected on these, so that allows private attorneys to do some work, and maybe not have to charge that much money. Otherwise, in events like this, you may do an intake at Disability Rights Iowa, where we provide legal assistance if the case fits some of our areas of focus for that year. That process, I could talk about the timelines, but that would get pretty convoluted. What you really need to know is there's certain timelines that try to make that process run quickly so that there's a decision made during that time. When you file a due process, wherever your child is educationally placed at that time, and that includes support services, everything in their IEP, whatever that is at the time, stays that way till after the due process hearing. Before you get to the hearing, before you go in front of a judge, you have an opportunity to mediate, and that's voluntary. So you can mediate, and if you don't make a decision at that time, you can walk out and still have your hearing. If you mediate and you do make a decision, then that decision becomes legally binding and you do not have to go to hearing. In Iowa, seems that we do an alright job of mediating things out. Last avenue you can take is what's called the state complaint. That's when you file a complaint with the Department of Education. Once again, you allege, you put in there saying that these events have occurred and we believe they're violations of the IDEA. And then the Department of Ed looks at that and says, okay, it looks like they did allege some facts that would be violations if they did indeed occur. Let's open up an investigation and let's investigate if this occurred. And they do a full investigation at that point and then write a decision based on that. That is not necessarily a legal proceeding. You don't need an attorney, and there's typically no attorney involvement, but you can have one if you would like one. So that's the different types of dispute resolution avenues available for you as the parents.
So all of these things that we've just talked about, especially these dispute resolutions, how many people have been to a meeting and they slide the book across the table at you and they say, here's your procedural safeguards, and you say, no thanks, I've got 16 at home. Please, will you take that book and read it? There are so many things contained within that procedural safeguards manual that are going to help clue you in to what your rights are for your student with disabilities. And they're really, really, really important, especially when you get to the point where you're not agreeing with what the school would like you to do. We're going to open it up for,
So measurement and progress. You know, you look at your IEP when you have one, right? And you got the goal written out, and it'll say, it should have a statement about your child's performance and how it correlates or how it connects to gen ed peers, right? Then you have a baseline. It should be a measurement that says, where are they at now in that goal? Then you have the goal. Where should they be in 36 weeks or whatever, right? Basically a year from the time of the IEP written. And then underneath that, there's this thing that talks about progress monitoring, right? It talks about we're going to collect data this much and so on and so forth. And we're going to graph it maybe every 2 weeks, something like that usually. And then it'll say we're going to review that data. And if it doesn't always say this, but here's a general one that I see a lot, and that is if 4 points are above or below the aim line. Aim line meaning on a graph of data, baseline to goal, right? Or if it's an extinguishing behavior from here to here, right? If 4 points of data, consecutive points of data fall above this or below this, we're going to review and look at an instructional change. Now, I'm not sure if all of you all read that and think, well, I don't really know what that means, whatever, and move on, right? But that is important to look at because you want to pay attention to, one, is data being collected? Because sometimes it's not, right? And the whole point of the data collection is what? To tell everybody involved whether or not this child's progressing and whether the supports and services are working for that goal, right? So, yes, it's a big issue. So, what you do is when you look at that, you want to look at that data and one, see what it says. So, you know, after about getting close to a year or whatnot, especially when you come around to your yearly review, if you haven't had an IEP meeting before then, you're going to look at that and you're going to have should have a lot of data on that graph that follows that goal. And that graph should look like they're meeting the goal, right? That's the whole point, or at least progressing towards it. If it shows a digression, we got a problem. And if it's showed a digression throughout the year, your question should be to the teachers and administrators is, what are we doing about this? Why haven't we caught this earlier? If they're not following their own progress monitoring rules, which you'll find on the bottom of that goal page, that's another problem. Because they make those rules not just because you fill in the box. That rule is to try to keep folks on the review throughout the time period on what's going on with this child. So if they're above the goal line, that means we might need to change the goal. They got it, right? They might have it. We don't know. We need to review the data, right? If they're below the goal line, what's happening? They're not making the goal. They might not make the goal for the year. Do we need to change supports and services? Do we need to change instructional strategy? Do we need to have another IEP meeting? Figure out what's happening. We won't want to keep either kids stagnant or way above with goals that are meaningless, or digressing and not meeting the goal at all. In fact, getting worse. That's the whole point of the data. So that's important stuff for you all to look at, because I'm not sure when I show up at IEP team meetings and when I get involved with due process and other things like that, I'm not sure if we're taking this data and actually using it for what it's supposed to be used for, or if it's just become an exercise in data collection that just sits there on the page. And I think it behoove you all to try to figure that out or ask questions about it, because if you don't understand it, somebody should. It shouldn't be something that everybody sits around dumbfounded at the table and says, I don't know. So if you can ask the question, and very much should, if that looks a little weird to you and doesn't make sense. And not making sense means digression, not following progress monitoring rules, and stagnation or way above goal. So that's very important, and that is part of the law. They got to be paying attention to that. And we can win a lot of due process complaints based upon that, because it basically says at the end of the day, you're not implementing this IEP appropriately. You got this nice piece of paper with a bunch of data on it maybe, but it don't mean anything at the end of the day if it's not implemented in the classroom, and we're not actually paying attention to what's going on with this child in reality. And that's what the data and the review of the data is supposed to be doing.
Instruction for students in special education is supposed to be two things: research-based and data-driven. We don't do my gut tells me. Research-based, that means, and there is a definition if you want to really go into what a research-based program means. It means that it's been peer-reviewed. There's data behind the research of the program to show that it is successful, and then those decisions need to be data-driven. I've been around in special education a long time, and so 20 years ago, I was part of the pilot program as they were developing these data graphs that are there, and it was wonderful because, of course, we had people who were really implementing this well because they were trying to test it to make sure it works. So when we were looking at math goals, we could look at the data. Here they go, progress, progress, progress. Ooh, they dipped down. Why did they dip down? If you look at your data, you should have lines that come for that will explain. They may say, it'll be really faint, it'll say things like school break, instructional material change. So by looking at that, we could see every time a new concept was introduced, there was a dip, and they got it and came back up. So the line, it wasn't always a progress line like this, but it was like this. It was still going up and up. And that's when my husband, who's not part of education, he's an engineer, he's like, oh my gosh, I finally get it. This is what it is that we're trying to see. I can see that they're actually learning, because we know that our students with disabilities learn at a much slower rate, often. And so this way we can actually chart, and that's what that data is for. It's not just an exercise. We've left time to take questions, because we know when we come to conferences like this, there are lots and lots and lots of questions. And we look forward to answering those questions for you. I would like you, though, to think about not making your question too student specific. Try to ask it, in the general, and if there's a lot more detail than what we're able to really answer in a public group, we'll talk to you afterwards. So, with that, who has a question? And we're going to bring the microphone around.
The last thing you talked about with asking for the graphs and stuff. What is a reasonable thing for us as parents to ask for to get that? That came up in our recent IEP meeting, and I asked to get notified on I don't remember if it was monthly or quarterly basis.
this like a Donahue.
I know.
I just dated myself a little bit. So, it'll say in the IEP once again, quarterly is what I oftentimes see. Right. It'll say that it should in your IEP, and I would use that document if it's right. Like if there's 4 times, right, and if you're on quarters, then I would use that document to say, hey, this says I'm supposed to get this at this certain time, and I'm not, and I need it because I'm an equal member of the IEP team.
Here, just a minute. I'm going to come over there. I'm trying to think if there's something more in your question that maybe didn't get answered. So we'll come back.
As far as the graphs, like when they do give them to you, how far back should they be? Like, should they just be since the last IEP meeting? Should they be for the whole school year? How many months should be on those graphs?
Typically a graph is going to go from IEP to IEP. You know, an IEP is good for a year. So typically you should be seeing that graph going for that entire life of that goal in that school year.
That's
Correct. A whole goal. Oh.
And related to these questions, I've just been researching the Family Education Rights and Privacy Act, and really parents have the right to request those records at any time to see your students' records. Now it's a right to inspect them. They may charge a copying fee if you have to copy them, but under that law, you can request them anytime.
I don't think did we skip the observation?
I just was thinking of that also. That I didn't remember. That I don't know how we skipped that one. Yeah. So there's a slide in there that is called "When Can I Observe My Child?" We must have been thinking along the same wavelength. What do you mean I can't observe my child in the classroom? This is a question that we do get, and Jane just talked about the Federal Education Rights and Privacy Act, or sometimes it's called FERPA. It doesn't specifically prohibit a parent or a professional working for the parent to observe the parent's child in the classroom, and that comes not out of that comes out of a letter that the Office of Special Education and Programming did OSEP that came from December of 08, and it's called Letter to Mamos. And in that letter it says, of course you can come in and observe your child, and you can have a professional working for you. That's often the sticking point that we hear. However, we encourage school district personnel and parents to work together in ways that meet the needs of both parents and the school, including providing opportunities for parents to observe their children's classrooms and propose placement options. So there is a letter from OSEP that has come out and said, yes, this can happen.
In this particular case, and I wanted to say to them, hey, I would like to come out and watch what's going on for many days regarding, and this is, I'm sorry, but it is child specific in this case. I'm able to go do that. So if I have any input and say that I can see what's happening here and bring it to the IEP meeting, then that should be able to be, yeah, okay, I knew that, but I didn't know how. Thank you very much. Yes.
Letter to Mamos.
Okay.
Because my special ed teacher used to say that to me. You can't come and see. And one time I saw the principal in the hallway and I said, I want to come and see. What do I need to do? Turns out they made changes before the next day so that I couldn't come and see, but they were good. But it's like, yeah, what do you do when they don't follow? I mean, it's like,
That's always the value of coming to presentations like this. I'm also the parent of children who have survived and thrived in the special education system and now are adults. And there is no special handbook that anybody gives you that tells you how to be a parent of a child in special education. So that's why I don't. Oh, maybe. You know, it used to be that I've always said that good parent participation for my other kids was I baked chocolate chip cookies and supervised field trips. And it's not the same. So that's why I say to you, read the procedural safeguards manual. It is, but read it anyway. And then come to things like this where we give you opportunities to ask questions. There are groups like Find, which are on the Ask Resource website, which help link parents together. I've talked about for years my network of friends. Can you believe we all have kids with disabilities? It just sort of happens that way. We come together and we share the knowledge that we have learned. Becoming an informed parent is the way you're best going to be able to help your child. There are websites out there like Rights Law, which have a lot of different things. They have a book called From Emotions to Advocacy, which is not a law book, but it's a way for you as a parent to learn how to effectively advocate for your child. So it's important we have to educate ourselves. That's how this is going to happen for our children.
The data that they do collect that is for the IEP, can the school district use that to exclude your child from activities like a class field trip?
I'm assuming this is going to be behavioral data, just without knowing. Well, I don't think there is an answer that I can give you for that without really getting deep into the facts, because if yeah,
and I'm going to talk in general, but I'm going to let you think. Believe it or not, these answers aren't always simple answers. So when you go back to the development of the behavioral intervention plan, the behavioral intervention plan, the purpose behind that plan is to develop a plan for positive behavior supports. And so I would argue that anything that becomes punitive, like taking away activities and field trips, may not be following the behavioral intervention plan. Possibly.
And I think one of the questions is, and we've had this before, where the child's been placed in like pretty much themselves and a teacher in a classroom, right, for a shortened day. And so they're not with the gen ed population at all. And so behaviors are of concern. And so then the question becomes field trips that are going to be successful, because you don't want to set the child up to fail either. So then that question needs to be put to the IEP team. How do we begin? Because one, in this scenario that I'm bringing up, if they're on a shortened day and they're not with any gen ed peers, there should be a plan to transition them back to full day with more gen ed peers in their day. Gradual, maybe, depending on the child. It should be individualized. But there should be some type of plan in place. And I would argue from the moment that they begin to be in that very restrictive environment, there should be the starting of a plan to get them back out of that restrictive environment. Part of that might be field trips. We did that for one of our clients that we had that's in this exact predicament that I'm talking about, where he was able to begin the transition, and part of that plan, he began the transition into not only some classroom type stuff, but also field trips with the appropriate supports and services. So maybe he didn't ride the school bus one time. He rode with mom the first time, and then was kind of had mom alongside him at the field trip. Right, exactly. So it was taking into account what are his needs and what needed to happen then for him to begin to be okay with the situation himself as well. And so after time, he was in field trips. But to answer your question about, I think Beth answered the question of using field trips as punishment. I think that's a difference. There's a difference there between that and if it's being thought of as how do we work with this particular youth that might struggle in these particular situations, and how do we have the appropriate supports. They're very different questions. I'm going to take that away because you don't do this, that's very different than I'm not sure we can do this with you, but how do we move this into a place where you can? Let's try to figure this out so you can be successful at it. Not I'm taking away because you're not being compliant.
And you can also get into the whole question of, is the field trip a part of the curriculum?
Right.
Or
Right.
was it a reward? Some schools have like perfect attendance parties,
Mhm.
and they go roller skating or those types of things. That's different than something that's part of the whole curriculum.
The other thing I think I heard you say, and then I want to just double check to make sure that we don't have other questions, otherwise we can keep talking about this. You said that, well, the behavior wasn't on the behavior plan. To me, if the behavior is significant enough that it's going to be keeping him from accessing the general education curriculum, which the field trip should be part of, we just don't go on field trips. They are part of the curriculum. If the behavior is significant enough to keep them from accessing the general education curriculum, there should be something included in the behavior plan to account for that.
So on the behavior, that's part of a behavior goal. And they're saying, well, you haven't met this, this, and this, so therefore and it's not a privilege. It shouldn't be a reward. And like I said, the only way it starts to make sense is depending on your educational placement, and that factors in. But if they're just in a gen ed classroom and they're saying, well, you didn't get enough behavior points, you can't go on the classroom field trip, or we're going to the science center and we're in the science classroom, then we got problems. Right. For And the whole point of the IDEA is, maybe it's a misnomer to call it special education. It needs to just be thought of as equal access. So that includes specially designed instruction, accommodations, all types of things that are kind of like a service and support package, right? That allows that child equal access to what? The gen ed curriculum. Are field trips a part of the curriculum? Beth said it well when she talked about if they're a reward versus actually something that they're going on that's related to what it is they're doing in class, right? So I think that's important to remember, and that's always the basis at which you work out of. Is this about equal access? Okay.
But it has to do with the suspensions you were talking about, because last year they introduced suspensions to him, to my son. It just came out of the blue. And we went through that. We went from being at home to at school and suspensions. And I specifically asked them, by definition, what are we doing and how are you even coming up with this and what's all that going to be looking like? This year, because of a lot of changes and many, many IEPs. Similar behaviors have happened a lot more this year than last. And they haven't said to me, these behaviors now constitute a suspension in or out. And I'm like, what's the difference? He had behaviors last year and you did that. And he had behaviors this year and you're not. Yeah. Okay.
One of the things that we can find out when you have a challenge behavior, when you have a child who is being suspended either in school or out of school, first of all, I would strongly encourage you to have the challenging behavior team come in and look at that, request that. But yes, that's through the AEA. They're specifically trained. When you have a child who is being repeatedly suspended in school or out of school, sometimes all you're doing is reinforcing the behavior. And in your case, maybe that's what they discovered, that by suspending, all they're doing is reinforcing the behavior. So the student learns that they do something, they'll get kicked out of school, which is exactly what they wanted. So, yes, and somebody may have wised up to that. You had a question here.
No, hopefully two of them are pretty straightforward. The WIOA, is that federal funding or is that dependent on who's governor here? Federal, okay. Sorry, yeah, makes a big difference. Regarding some educational benefit, are you aware of any cases in the pipeline that might challenge that standard? And then my last question is, what do you see, and this is probably the hardest one, what do you see with school budgets being squeezed and special education especially being squeezed? What are you seeing in your practice?
Okay, so the first part, the Supreme Court case is called Raleigh, and that some education benefit standard is from that Supreme Court case, so people call it the Raleigh standard. Right now, I mean, yeah, it is what it is, and there has not been a movement necessarily that's been successful to change that. Although some folks, I was reading a couple weeks ago, that folks are looking to try to basically try and talk to the United States legislature about changing the IDEA, but to essentially overturn it through legislation, I don't know if I see that happening. I don't know. I don't have a crystal ball, but when reading that article, I didn't feel like my gut was telling me this is going to really happen this way. I just don't see it happening. And one of the reasons is because the next part that you're talking about, I think, to just talk about funding, one, the IDEA has never been fully funded at the federal level.
Only about 27%.
So that squeezes states. You have a mandate, the IDEA, that's not funded. I think Beth and I would have a lot less work if it was more funded. It doesn't mean it would be perfect. It just means there'd probably be less work, because what it puts the school districts in the place of being gatekeepers for their special education funding and saying no rather than yes most times in order to guard what little funds they have. It also puts us in a predicament when we ask for remedies, when we're actually in a legal issue, in a battle, and we say we want comp ed for this student, which means payment for additional services, right? Well, that payment's coming from somewhere. And if it's already an underfunded system, does that matter to the larger system? It's just a question that we have. So really, funding matters. I think it's why Beth and I have so much business. One of the reasons why.
We're also free.
Yeah, we're free. But I'm saying, it's why there's more no's than yeses at the IEP table.